Welcome to Property Law 101. I'm Sara Bronin, and I've created this series to help you understand the basics of property law. I'd love to hear from you either on Twitter or through my website where you can sign up for a mailing list. So Property Law 101 covers four fundamental questions. What is property? How do we acquire property? What can we do with property? And how are property interests held? So today we're talking about that first question, the nature of property law. And we're doing it through a discussion of the Blackstonian bundle of property rights. So Blackstone, does this name sound familiar to you? Who was William Blackstone? He was an 18th century English jurist. He went to Oxford University. He was a fellow at All Souls College, quite a distinguished character. But his big contribution to all of us was, and to the law, was a series of essays or commentaries about the legal system as it existed in England during that time. Now, every property law class starts with a discussion of William Blackstone. And I guess one question that you might have is, why do we care at all about what an 18th century English jurist has to say? Well, I'll tell you why, and it's because our entire legal system was based on English law and what we call common law. So common law is the kind of law that judges make, judicial precedent it's called, as opposed to statutory law, which are the laws as written, the laws on the books, we call those. So to understand what common law is, you have to understand what judges say. And that's where Blackstone comes into play. He tried through his commentaries to synthesize and explain the common law in a variety of subject areas. When it came to property law, Blackstone had a specific idea about what property law is. He considered it a bundle of rights, which we sometimes call a bundle of sticks. So what's in this bundle? I'll give you a few things. The right to possess, the privilege to use, the right to exclude, the power to transfer, and how about the right to quiet enjoyment of property? So in the Blackstonian vision of property, these property rights go on forever, in perpetuity. They extend all the way up to the sky and all the way down to the center of the earth. And what he calls this conception is fee simple. So fee simple, absolute ownership of property. In the Blackstonian vision, there is no end and there is no limit to the fee simple. He rooted this idea in the notion that property law was handed down from the heavens to man. But as we'll see throughout this series, this concept is not accurate now if it ever was. There are many situations where you can own property but not possess it. There are lots of rules about what you can do with property, nuisance and zoning constraints probably being the most prominent among these. You can't keep everyone off of your property as Blackstone conceived of that level of exclusion. What about airplanes, for example? We'll talk about a case, Hinman versus Pacific Air Transport, that speaks to this question. The law might also stop you from transferring property in certain ways, including in discriminatory ways. And finally, you might have the right to maintain ownership to your property, or you might have no right at all. In other episodes in this series, we'll cover eminent domain. So Blackstone's vision of a fee simple isn't really simple at all. We see over and over again in property law that property rights are not absolute. They are constrained and they are relative. So that's why I consider and propose to you that the Blackstonian concept of property really is perhaps just a myth. I'll leave it at there. See you next time, and thanks.